Attention real estate investors, entrepreneurs, and other small business owners. If you own your own business or have a small business with partners, then you're probably concerned about asset protection. After all, what good does it do to make money if you can't hold on to it? At the end of the day, it's not what you make, it's what you keep, right? So now, what would you say if I told you you were about to learn a little-known method to double your asset protection? Now, this is one video you don't want to miss.
Welcome to Rock Real Estate with Stu Simone, where we make real estate informative and fun. And now, here's your associate broker, real estate attorney, and mortgage loan originator, Stu Simone.
Hi everybody, Stu Simone here. When you think about it, keeping your money is at least as important as making it. If you don't protect it, somebody is going to take it away from you. So it always surprised me when I see so many successful business owners and entrepreneurs who are running their businesses as sole proprietorships, having rental properties in their own names. You need to look at protecting your financial assets the way you do your physical assets. I mean, you probably got a security system at your home and your business that you pay for every month. Put up fences and security lights to keep out thieves, and probably have security cameras. You've done everything you can to keep a thief from taking your physical property. But the truth is, most business owners have a better chance today of losing money in a legal or financial attack than from a burglar. So why not fortify the protection of your business like you do with your home? Will legal and financial attackers come after you if you've got legal protection, when there are a lot of people who don't have any protection? The odds are much lower. And if they did, they'd run into legal obstacles that might make them wish they never had tried. So let's talk about asset protection. How about it? Asset protection basics. First of all, you need to understand some of the basic asset protection tools an attorney has available to use for your protection. Corporations, limited liability companies, LLCs, limited partnerships, trusts, benefit plans, retirement plans, and even contracts can all be used as asset protection tools, and the tools can be used in conjunction with each other. On the other hand, it's usually best to keep it as simple as possible. There are plenty of advisors and attorneys that try to set you up with layer after layer of asset protection. They use common tools and stack them on top of each other. The feeling is that if one is good, then 10's even better. Usually the push for complexity is simply a way for the asset protection firm to make more money. Let's talk about traditional and double asset protection. Corporations were created to protect the investors, the stockholders and managers, the officers and directors, from liability that might occur because the corporation was doing business. Corporations were not created to protect your stock in the corporation from being taken away from you when you get sued personally or have big problems. So we'll be talking about this double asset protection later in depth. And by the way, I'd like to thank Lee R. Phillips, JD, a court counselor to the United States Supreme Court, who has been the leading advocate for double asset protection. Let's talk about traditional and double asset protection. The corporate shield. Congress created corporate protection to encourage people to fund and run companies. If you take the risk of starting your small business, or if you invest in someone else's company, Congress has agreed to protect your personal assets from disastrous events. But the business entity you create for your small business is different than the Wall Street companies. When you set up a corporation or LLC, you own it alone or maybe with another person or two, and is called a closely held company. And that means the courts will look at it very carefully to make sure that you treat it as a real corporate entity rather than just your alter ego. Technically, the legal structure is the same as with the big corporations, but the care and feeding of your closely held company feels very different. The laws won't protect you from everything that happens in the business unless everything associated with the corporate structure and maintenance of your company is done just right. Most asset protection for closely held companies fail when they are legally challenged. Small corporations and LLCs are often lacking when set up. Even if they are set up well, they are seldom managed correctly. Now, there are 16 corporate formalities you have to do routinely in order to ensure that your corporation or LLC will actually protect you when there is a problem. The fact is, a high percentage, probably well over 50% of the corporations in the United States will not protect the officers and directors simply because the owners haven't followed the corporate formalities. In your corporation, you will not only be a shareholder, you will be an officer, maybe the president, CEO, and director of the company. That's multiple roles, and that means you may be exposed to a lot more liabilities than the average Joe shareholder or stockholder of a big corporation. Because if somebody can pierce the corporate veil, it is the officers and directors who become liable. So with all that liability exposure, you can see how important following these corporate formalities are. So what happens when you are doing business as your corporation or LLC and you get sued? Well, the plaintiff will always sue your corporation or LLC and you. When you get to court, you'll no doubt ask the judge to dismiss the suit against you personally, but the judge will start down the list of formalities that the corporation must follow. If you cannot establish that you have followed the corporate formalities, then the judge will simply say how sorry he is that he can't use the corporation to protect you. He'll have no choice but to pierce the corporate veil of your corporation or LLC and allow you to be personally liable for the misdeeds or mistakes of the corporation or LLC. That means your home, your car, your bank accounts can all be used to pay the plaintiffs if they win. Now, on the other hand, if you listen to my advice and remember to follow your corporate formalities, their frontal attack against the corporate entity will fail and your personal assets will be safe. Phew. A personal liability for your business entity. Okay, we talked about the corporate shield and how it can protect you from a frontal assault, but now let's talk about a different kind of legal attack. What happens to your company when, let's say, you get divorced or sued, or one of your partners goes bankrupt, or he gets divorced or sued, or suffers some other kind of personal disaster? How do the personal disasters of one shareholder or member affect the other shareholders and members? It's likely none of your advisors have ever discussed these issues with you until now. Yes, there's a whole other universe of asset protection independent of the corporate shield world, and you should pay attention because the outcome of your personal disasters or those of your business associates will be very different depending on how you structure your company. So business or corporate activities are occurring out in front of the shield, while personal activities are occurring behind the shield or inside of the shield. Now, as we've been saying, in a corporation, and that includes C Corps, S Corps, or LLCs, if the attack comes from the company side of the shield, then individuals are protected as long as the corporate formalities are followed. However, if the attack comes from behind the shield, directly to you, the individual, or one of your partners, then the corporate shield does not protect that person. Even worse, it also doesn't protect the company itself and its assets, or any of the other co-owners of the company from an individual's personal disasters. So your assets are at risk even if the questionable conduct was done by someone else in your company. If you have a successful business, your business is probably your most valuable asset. So in short, your business also needs to be protected from the inside. Yet Congress has never given us a shield to protect us against our personal problems. So now it's time to talk about double asset protection. One way to protect yourself against attack from the inside of the shield is to carry a lot of insurance. So you should look at beefing up your homeowner's policy, your health insurance, and auto insurance. Make sure you have a big umbrella policy. But the problem with insurance is the coverage. We know that insurance companies love to limit their coverage, adding tons of exceptions and addendums. When it works, insurance is great, but the insurance company's job is basically to get out of paying your claim. So there are lots of holes in insurance coverage. So if insurance fully doesn't handle the claim, you will be sued. Double asset protection for real estate investors. Right now, let's zero in on real estate investors, as multi-property and multi-family landlords may be at the biggest risk. Many real estate investors are advised to hold assets in land trusts, which can make it more difficult for plaintiffs to find those assets. But if you are attacked personally, the land trust will not give you protection. For asset protection purposes, it is a good idea to hold each property in a separate corporate entity rather than your own name or in a land trust. Obviously, there's a limit to the number of entities you can afford and manage, as most people can't effectively manage probably more than 3 to 6 entities. If you have a lot of properties, Why don't you logically group them into a limited number of entities? Now the question is, what kind of business entity should you use to hold the properties? Now let's say a tenant slips and falls. The tenant will have to sue the entity that owns the building. Now this attack is coming from the front, the company's side of the shield. So assuming that the corporate or LLC shield holds, the most the tenant can get is the assets of the entity that owns the building. So maybe you have 1 or 2 properties in there. Other assets, including your ownership of the entity that owns the other apartment buildings, will be safe. So a corporation will do just fine against a frontal attack. But what happens if the attack comes from the inside or the personal side of the shield against you or one of the other owners of the corporation? If that attack is successful, the spoils of the suit may well include your stock in your close C or S corporation. The creditor now would have voting rights and could replace you as an officer and director with himself, and then he's running the show. So then you not only lost money and assets, you've lost your own company. Now, what if the entity was an LLC instead of a corporation? The creditor will also get your membership interests in the LLC, but with a properly drafted LLC operating agreement, like we do at Simone Legal PC, the creditor cannot take over control. When a creditor gets a membership interest in an LLC, the creditor must get what is called a charging order to come against the entity. The charging order limits the creditor to being able to receive the financial benefit of the owner's interest in the LLC or limited partnership. Now, this is very different from being able to seize the stock in a corporation and have all the voting rights and management rights. It's only limited to the financial benefit. If the LLC document is written properly, the management of the LLC is intact and free from the creditor's influence. In fact, the managers of the LLC can basically make life miserable for this new member. You can actually siphon off all the income and tax benefits before the creditor can get anything. And in some cases, you can even shift the tax burdens to this new creditor. So the bottom line is that using the LLC structure, you still have control of your company even after losing a lawsuit against you personally. But if your entity had been set up as a corporation, you'd have nothing. That's a very different outcome. So, how do you get charging order protection? Obviously, you need to consider an LLC as the basis for your business structure. But that's just the beginning. When you set up an LLC, the articles of organization and the statement of information are simply basic papers that the state requires. Many people forget all about the operating agreement, or they might just get a generic boilerplate version online or from an attorney. However, the operating agreement, as we're finding out, is critical because you basically get to define what charging order protection you'll get out of your LLC in the operating agreement. If you write your operating agreement with the nuggets that beef up charging order protection, courts will honor those documents in almost every situation. For example, if the operating agreement says that no distributions will be made to an assignee or a transferee of a member's interest, you may have just eliminated the creditor's possibility of ever getting a distribution of profit. Without the possibility of a distribution, the economic interest the creditor gets is basically worthless. So these types of little changes in an operating agreement make a huge difference, as you can see. Now, most attorneys and websites never address these issues. Your advisors have probably never thought about charging order protection, but you need to. The charging order aspect of LLCs is one of your most powerful asset protection strategies. Learn how to use them, and you can sleep a lot better at night because your assets are protected from the business liabilities and many of your personal liabilities. This means you can get protection from both the front and the back side of your corporate shield. Now, if you want asset protection, do not wait. Because if you're already in trouble, basically your asset protection options are non-existent. I get calls all the time and people in trouble, they want to do some asset protection. Can't do it. That's why you gotta do your asset protection planning now before the problems arise. All states have fraudulent conveyance laws which look back at transfers from 2 to 7 years. If you move assets for less than your fair market value, if you give them to kids or another creditor, the courts can use the fraudulent conveyance laws, basically get the assets back by voiding the transfer, and your creditor gets those assets. However, if you put the properties into an LLC now and get membership interest back in exchange, then there might be a very different outcome. And this cannot be characterized as a fraudulent conveyance because you're getting equal value worth of membership interest back in exchange for the property you put in the LLC. That's a fair exchange. All you're doing is you're just changing the nature of the asset. With your other properties in the LLC, when the judgment comes, the creditor must get a charging order which limits his remedies. All the creditor then gets is a lien against the economic interest represented by the membership interest. And that's all. And as we said, we can get out of that. By law, you have protected your other properties. So there you have it. You just learned about something that the vast majority of small business owners and even many attorneys know nothing about. In short, if asset protection is what you're looking for, and I think it should be, then an LLC with a properly drafted operating agreement is what you want. Following the teachings of U.S. Supreme Court Counsel Lee R. Phillips, Simone Legal PC drafts these double asset protection LLCs on a custom basis. We also offer a peace of mind package that combines the asset protecting LLC with a revocable living trust to handle both your asset protection and estate planning needs in one solid, time-proven structure. So contact me anytime, and I'd love to discuss asset protection with you in detail. I hope you enjoyed this video and know you learned something important to help you keep the money you work so hard to earn. Please like and subscribe and stay tuned for more valuable real estate information here at Rock Real Estate.